All right, welcome back. Nigerian pastor versus ex-wife, 1.5 million pounds. UK properties battle. Yeah, let's get through this real quick. Let's run through some quick story, warm-up stories. I stumbled into this on Premium Times, and I thought we should just look at it and see what is happening out there. It's crazy out there, isn't it? Exclusive. After bitter divorce, Nigerian pastor ex-wife battle over 1.5 million pounds UK properties. And this is a pastor. Apparently, this is a very popular pastor. I've never seen his name before. Pastor Francis Irabor. When the marriage of the pastor and his wife was dissolved in 2017, that's a while back. It's like 7 years ago. Yeah. It set off a storm of legal actions in the UK that involved the church. All right. Nigerian pastor Francis Irabor and his ex-wife August, how do you pronounce that? August Irabor are embroiled in a legal battle over their family assets in the United Kingdom following the bitter separation. I'm reading directly from Premium Times, Nigeria. The extensive legal battle also involves the church Mr. Irabor founded in Abuja, the Great Calling Ministries worldwide. Before the family's relocation to the UK in 2014. All right, the church gave him loans to facilitate the relocation and to acquire 2 houses in the UK. These people commingling money left and right. So when the couple's marriage was dissolved in 2017, it set off a storm of legal actions that involved the church. At the heart of the battle were 2 houses in London, cumulatively worth 1.5 million pounds, which Mr. Irabor acquired with the loans he obtained from the church he started. Court records obtained by Premium Times reveal how the church's spirited efforts to recover the loan it granted Mr. Irabor clashed with Ms. Irabor's attempts to claim her share of the family assets. In May 2023, a family court recorder, Judge Andrew Willett, ordered Mr. Irabor to pay her a lump sum of £750,000. That's last year, and other costs she incurred on a clean break basis. Mr. Irabor did not appeal the judgment, but he supported the church to file an appeal against the verdict at the family division of the High Court, Royal Court of Justice in London. The church hinged its appeal on the contention that the family court's verdict left it with no guaranteed means of recovering its unpaid loan from Mr. Irabor. The church hinged its appeal on the contention that the family court's verdict left it with no guaranteed means of recording. All right. On 11 April this year, 2024, the judge Jonathan Cohen upheld the verdict of the family's court recorder, a judge awarding the lump sum of £750,000 and other costs in favor of Miss Irabor. She was burdened by debts, of course. This is the West. She was burdened by debts, including £50,000 in student loans and the upkeep of their 4 children in London at the time. Despite Mr. Irabor not being a direct appellant in the case, the High Court gave scathing remarks about him, casting him as a man living a highly comfortable life while paying nothing towards the support of the 4 children or their mother. Then as far as genesis of legal battle, the Irabors were married in 2008 and have 4 children aged 14, 13, 11, and 8. In February 2013, Mr. Irabor co-founded their church, the Great Calling Ministries worldwide in Abuja, Nigeria's capital. He, his wife, and his sister were the trustees of their church, but his wife has been removed, of course. And Mr. Irabor's sister remains a trustee, of course. On the 30th December 2013, barely 10 months after its founding, the church offered a substantial loan to Mr. Irabor to Japa to England and escape the threats of a militant organization in Nigeria. 1 week later, the pastor entered into another loan agreement allowing the church to lend him 550 million naira. Okay. The church, let me see something here. The church transferred $1.56 million. Jesus Christ. The dollar equivalent of the money to Mr. Irabor's account in July 2014. Mr. Irabor used the money to purchase a 5-bedroom family house at 6 Daisy Close in London in his sole name for £950,000. Soon afterwards, the family relocated to the UK and claimed asylum. According to the court, while Ms. Irabor got asylum with permanent leave to remain in the UK, Mr. Irabor's precise status could not be ascertained. Mr. Irabor again decided to purchase another property, a flat, in Goldhawk House in London. The purchase price was £365,000. While trying to buy the house himself, he fell victim to fraud and needed another £220,000 to complete the purchase. He contacted the church, which promptly granted him another £220,000 loan. Again, I'm reading from Premium Times, Nigeria. Both properties were purchased in the sole name of Mr. Irabor. Days after completing the purchase of the second house, Mr. Irabor and his wife separated. In November 2017, they were divorced in Nigeria. Meanwhile, since June 2017, the first loan had become due for repayment. 42 months from his grant, there was no interest attached to the loan. That's a red flag. Was it actually a loan in the first place? Church surfaces in London court. Shortly after the dissolution of the marriage of the Irabors, the church requested a restriction on the charges register of the house at Daisy Close. All right. This meant the church sought an order to stop possible disposition through sale, transfer, gift, or new mortgage of the registered property. Less than a week later, the church also sued Mr. Irabor in the Nigerian court for the money he owed under the 2014 agreement. I'm curious now, who is in charge of the court of the church? I'm curious. The church and Mr. Irabor reached a settlement. Is that the same person? The church and Mr. Irabor reached a settlement very quickly. Maybe because it's the same person. Very quickly, and judgment was entered in the Nigerian court for the sum lent. Ms. Irabor was not a party to the Nigerian proceeding and knew nothing of them. In due course, the district court in London issued an interim charging order on the house at Daisy Close to make it serve as security for Mr. Irabor's debt. The church also applied for a final charging order on the property. Pastor's ex-wife launches legal challenge. On 13 December 2018, Miss obtained leave from a district court to institute financial remedy proceedings under the Matrimonial and Family Proceedings Act, MFPA 1984. The law is a crucial piece of legislation in England and Wales that provides a legal framework for addressing financial settlements in international divorce cases. Also, at the first appointment of the proceedings on 16th September 2019, the court gave the church leave to join the suit as an interested party, an intervenor. In both decisions of the court permitting Ms. Irabor to institute the action and allowing the church to join as an intervenor, the court made it clear that the central issue in the case was to determine whether the church had a beneficial interest in either of the two parties registered in the sole name of Mr. Irabor. While Ms. Irabor sought £750,000 and her cost of the procedures, Ms. Irabor offered her the £372,000, proceeds of the sale of the Gold Hawk house. On its part, the church sought a final charge over the Daisy house. Preliminary court judgment. After an extended trial process from 16 September 2019, the district court judge handed its judgment on 9 March 2022. The judge held the legal and beneficial ownership of both parties at Daisy Close and Gold Hawk House remained with Mr. Irabor, not the church. Consequently, the court ruled that the equity in each property will be available for distribution between Mr. Irabor and his estranged wife in their financial remedy proceedings. The house at Daisy Close was valued £1.176 million, being £1.2 million less sale cost. Okay, so it's worth less than what the sale was. Okay, while the Gold Hawk House flat was agreed to have a value of £380,000 gross, that's £372,000 net. The net value of the houses thus came down to about £1.548 million. Mr. Irabor's total debt to the church through loans amounted to £1.274 million. That's a lot of money against those properties. As soon as the court gave its judgment affirming that the equity in each of the two houses would be available for distribution distribution doesn't mean cash on paper, okay, between Mr. Irabor and his former wife, the church swiftly applied to register the Nigerian judgment in the High Court. The church took the step, realizing from the district court judgment that it did not have the loan security which it had previously believed to be the case. Right, so you can't just use your mouth to say, my money is in the property. You actually have to have some kind of note or security against the said property. After this, the court granted the church an interim charging order to halt any move to dispose of the house at Daisy Close. The church also applied for a final charging order. The application for a final charging order was transferred to the family court at Plymouth to be considered alongside the financial remedy proceedings. Now, family court judgment. The recorder, the judge in charge of the family court hearing, delivered his ruling on 25th May 2023. The court awarded £750,000 lump sum to Miss Irabor after considering her needs, liabilities. This is not Nigeria. There are liabilities. There are actual recorded liabilities. Okay, as in like there are records. The total value of the two family houses and the debt Mr. Irabor owed the church. The court found that for her part, Miss Irabor had debts amounting to £110,000. Of this, £50,000 was legal fees, £59,000 in student loans, and a small sum of council tax arrears. Mr. Irabor is going to end up with nothing. Also, at the time of the trial, Miss Irabor was living in an unsatisfactory 3-bedroom council house in the southwest of London with all 4 children. Jesus. The court found that Miss Irabor was dependent on benefits. She was also completing a course of further education. On the other hand, Mr. Irabor was living in the former family home at Daisy Close. The court said, so she was probably kicked out of the house earlier before the court's judgment. He was spending a significant amount of his time in Nigeria, right? But he was also in the big house. He played a minimal part in the children's lives and was not paying child or spousal maintenance. The court rejected the church's request to make the charging order of the Daisy Close property absolute to enable it to recover its debt from Mr. Irabor. They can still recover their debt from Mr. Irabor. They're just going to have to manufacture all that money from thin hair somewhere. Probably not those properties. As long as those properties are on ground in UK, there's no way. Could it work? The judge did not stop there. He went further to discharge the interim charging order placed at the instance of the church on the property. Now the church appeals. Only the church appealed the judgment. It lodged its appeal at the Family Division of the High Court, Royal Court of Justice in London. The church expressed dissatisfaction with the family court's judgment, contending that it failed to provide clarity about Miss Irabor's housing needs. Okay. The church also argued that the court overcalculated Miss Irabor's debts. Specifically, it contended that the court appeared to have calculated a lump sum to enable Miss Irabor to repay her £50,000 student loan. Miss Irabor had a cumulative £110,000 debt at the time. It argued that the court failed to explain why the student loan was not left as a liability, since it would only be repayable when Mrs. Irabor began to earn a good income. I think some of these people they never experienced it. They never thought that, okay, all right, it's Yaki, all you have to do is just go to court. Oh, sorry, this one is in Jan, this is in London. In all this, the church contended that its loan to Mr. Irabor, secured by an interim charging order, received minimal consideration by the recorder at the family court. All right, so now the judgment on appeal. Let's see how this is going. It's longer than I thought. All right, so in his judgment on the appeal, pardon my manners, let me see, some people are here. Let's see who is here. Shout out to Black Diamond. Tonya is here. Marriott is here. Welcome. Natsu is here. Welcome, my people. Hit the like button as you're coming in. Do the needful. Thank you. Do the needful. Hit the like button. Okay, we're talking about Nigerian pastor versus ex-wife. £1.5 million. UK properties battle. And we're talking in the persons of Pastor Francis Irabor and Mrs. Irabor. Alright, so in his judgment of the appeal delivered on 11 April this year, the High Court upheld substantially the family court's decision. It only reduced the amount of certain costs conceded by Mrs. Irabor's legal team. Alright, so they had to agree to it. They were like, let's just let's have mercy on them, right? The judge, Jonathan Cohen, affirmed the £750,000 lump sum the court awarded to Mrs. Irabor. On the family court's assessment of Mrs. Irabor's need, Mr. Cohen held that the lower court was entitled to assess her need generously. Mr. Cohen said this was because Mr. Irabor had access to undisclosed funds. Of course, remember, he owns a church in Nigeria that all of this money came from in the first place. But this is years later. They left in 2014. We're talking about 2020. We're talking about 4 kids later. I don't know if the kids were born before that, but you get the gist. He had the sole use of a 5-bedroomed house in London. He had managed to buy himself a new car for £45,000. I bet it was cash. He was paying nothing towards the support of the children or their mother. That she was on a very tight budget. And substantially dependent on benefits were factors that fed into the recorder's judge's reasoning. He agreed that the recorder could have explained his calculations of Miss Irabor's needs more clearly and could have arrived at a lower figure than £750,000. But he said the figure that the recorder, as the trial judge, arrived at was not significantly more than Mrs. Irabor's needs. It's probably like £10,000. Mr. Cohen also ruled that the church's claim that the family's court verdict left it with no means of recovering its loan was untrue. Well, you should have the house must have some kind of document that shows it was a collateral. Collateral, what do you call it? The security collateral, something, like the assets that you put down to take a loan, right? The collateral, right? Anyway, Mr. Cohen also ruled that the church's claim that the family court the judge earlier agreed that the family's court finding that the church was not keen on recovering the loan. He wrote, the effect of the order is that instead of the church receiving some £1.1 million from Daisy Close, it will receive £370,000. They should feel lucky from the flat, and the balance of £420,000 from the Daisy Close surplus. Maybe they had some documents. They should be happy. This goes a long way to repaying the church. Mr. Cohen said it was always the case of the church, and Mr. Irabor that the loan would increasingly be covered as the properties appreciated in value. All right, the effect of the judgment is simply that the church will have to wait longer than otherwise would have been the case, Mr. Cohen ruled, pointing out how Mr. Irabor and the church had worked together, right, to pursue the case from behind the scenes. Maybe it's the same person, same entity, not person, same entity. The judge said tellingly he has not filed a notice of appeal from the recorder's order, albeit he supported the appeal of the church. Of course, we all support the appeal of the church. All right, may the best player win. Anyway, that's that story right there. I think it's just, when these people jackpot to new nations and stuff like that, they should just be aware that the systems, the judicial systems are probably tighter. As much as you want to benefit from the jackpot, just understand that all the bad behaviors will probably not be tolerated as much as it would be in Nigeria. You know, they should be happy they got some money back from that one sentence. But anyway, there you go. So what I'm picking up from that story is that woman was kicked to the curb. You know, once they decided they were going their separate ways, it was up to her to fend for herself, her children, and then she got on benefits. She was improving herself, and Baba probably just moved on and said, "Hey, being the daddy Geo that he is, But once you come into this parts of the world, everything is up for scrutiny as far as they can find. Myra says, what I find hilarious is that the man and the whole church are same. When will my people wake up? They are the same entity, equivalent, not exactly the same, but kind of, sort of. One controls the other, kind of, yeah. That's how that works. Anyway, that's the Nigerian pastor. Let me know what your thoughts are. Let me know what your thoughts are about that. I just thought it would be an interesting. This is how dirty things get when you end up in divorce in the poto. It's not always as simple as sitting on the dining table and using the spreadsheet and iron things out. No, it's not that simple. Okay, there are some things you will discover about yourself. Excuse me. Excuse me.
He shock you.
There's some things you will discover about yourself. There's some things you will discover about your ex-spouse. And it's not gonna be as simple as running to the courts. All right, everybody might collect. Okay, you might be dragging it out for as long as 7 years, 5 to 7 years, give or take, maybe. It's a very difficult thing to go through. It's no fun. Anyway, so I'm sure that man wanted to just like, okay, since you want to leave this marriage, leave everything and take your kids and go. It won't be the first to hear things like that out of Nigeria. It's just what it was. But the world is changing. So hopefully people are paying attention to how the world is changing. Some things you're able to get away with on both sides of the gender might not be as simple anymore. All right, do me a favor, hit the like button, share, subscribe, turn up your notifications so you're notified when we go live. And I will be right back. Check out this next segment. We offer evidence-based relationship and marriage resources and coaching to help you navigate the difficult times.
Don't just wing it. Learn the principles that work.
Download our 2 free books and book your complimentary coaching session now at manofprestige.com.